panelists. First of all, I'd like to thank everyone for being with us today, both in person and online. We really appreciate you taking the time to start your day with Fasken. And now I'm going to just say a few words about my co-presenter, Jean-Nicolas. He'll say a few words about me. Then we'll go over the administrative details for those of you who are relying on this presentation for your continuing legal education credits. So Jean-Nic is the head and co-leader of our firm's technology, media, and telecommunications practice. He's also the co-leader of our startup group, which has been wildly successful and which is often imitated but never equaled. Jean-Nic was the first lawyer at a national Canadian law firm to create a startup practice. And so while we're no longer the only national firm, we were the first. And Jean-Nic really blazed that trail that a lot of lawyers have tried to follow. Jean-Nic is, as I say, often imitated but never equaled, in part because of the diversity of his practice. He's worked on pretty much every complicated legal puzzle you can imagine, from patent pools to research consortiums to cutting-edge issues around law and AI. One of our major clients is Element AI, and we're very proud to be serving sort of the titan of the Montreal artificial intelligence community. And that's very much thanks to Jean-Nic. And one of the reasons we have him here today is that he brings a lot of knowledge about software specifically and high-tech in general, and the issues, both business and legal, that can come up when you've got those kinds of transactions.
Thank you, Michael. Well, a few words about Michael. I've been practicing for 23 years. I've seen a lot of young, up-and-coming lawyers, and by far, Michael is one of the smartest, more brilliant young lawyers I've ever had the pleasure to work with. So Michael, it's always a pleasure to work with you. I thought I'd say that in front of a live audience. Michael is the founder and chair of our video game practice group. He drafts and negotiates video game deals on behalf of developers, studios, and freelancers in the industry. He has negotiated against major global publishers like Electronic Arts on behalf of Montreal developers. Has a busy IP litigation practice that keeps him away from my transactional files from time to time. Has drafted factums for the Federal Court of Appeal, the Supreme Court of Canada, and actually is probably one of the youngest lawyers to have argued in front of the Supreme Court in a unrelated matter with respect to video games, but it was a minority language rights case that Michael argued in front of the Supreme Court. Michael, when are we expecting a judgment in that case?
Case was argued in May. We've got our fingers crossed that we're going to hear from them soon, and we were arguing in favor of minority language rights, specifically for francophones in the federal justice system. So fingers crossed that we're going to get a positive answer from the court, hopefully September, October.
All right.
So on that note, back to video games, and specifically your accreditation. This conference is accredited for 1.5 hours with the Quebec Bar, and that accreditation will be sent to you by email as proof of attendance. And to make sure that people have been tuning in for the full presentation, there's going to be a skill testing question that you'll have to answer to get your CLE hours. It's an easy question, but as we say, it's something that it sort of ensures that people have been paying attention for the full presentation. It should be lucky we're not like the doctors. The doctors at their CLEs are actually given little tracking devices so that they can't leave the room. So all we're going to do is ask you guys a question. Speaking of questions, I just want to say that if you have any questions, you can email them directly through the portal, or if you're in the room, ask them live, and we'll try to respond to them as they come up, or if we don't have time to weave them in, we'll address them at the end. And so we really do encourage full audience participation. It would be our pleasure to answer any questions that are sort of peripheral to the topics we're talking about, but that are important to you to have answered, whether it's business, law, or both.
Great.
And so on that note, we're going to quickly outline the presentation, and I'll turn it over to Jean-Nic.
Because I'm the oldest, so I get to do the intro.
He gets to.
All right. What I find, all right, for the non-lawyers, because we have a mix of lawyers and non-lawyers, and I always open these things with basically the same opening remarks, and then I'll zero in on the video game industry. But as you develop technology, you got to understand. And that goes to the title, which is own what you say you own, which is interesting for a lot of different reasons. But that's because ultimately what you're talking about when you're developing technology is really intellectual property. Why? Because it's the intellectual property behind the technology, the underlying IP, that gives you all sorts of little statutory monopolies with respect to what you're developing. And just by way of example, copyright gives you the sole right to reproduce the work protected by copyright. So you got that little monopoly. If you take a patent on an invention behind your technology, you have the sole right to use, sell, make your invention. And when we say own what you say you own, you got to understand that as lawyers, what we do is we always go back to the individual that was involved in the creation generation of the technology. And then we try to make our way from that individual to the company that says that it owns the technology. And basically, if you're, let's say, licensing an open source component or something, that's basically someone having a little monopoly right that gives you access to certain bits and pieces of that monopoly. That's all that it is. In the video game industry, what is fascinating is it's probably, in terms of technologies, the area where there is the most IP at play. And this is what we're going to do today. This is what you have on the slide, the outline and objectives, understanding the main types of IP involved in typical video game industry transactions, the ownership rules, again, going back to the individuals, who owns what, and how we can track the IP back to the owner or to the company that says that it owns the tech, and understand then how to structure your transaction to achieve clear IP ownership and then licensing that IP. And what is fascinating, again, in the video game industry is what you have on the slide. It's the breadth of the IP rights at play. For example, copyright, which again is sort of the right to reproduce the work, will protect the code. Software in our Copyright Act is deemed to constitute a literary work, like a book. It is what it is. Music, art assets, animations, all of that is protected by copyright. So again, the little monopoly that goes with that is the sole right to reproduce the work and so on and so forth. Trademarks. Trademarks will protect game titles, studio names, logos, etc. We'll get into the details of that, what you need to look for, where you need to be careful, you need to register, so on and so forth. Patents, today, the pendulum is sort of switching back to allow companies to protect software. We'll dig into that.
And so then there's a couple that are easy to overlook. I'm sure you guys have all heard of copyright. You've thought about trademarks and patents. They're big in the news. Industrial designs is sort of instead of the big three of copyright, trademarks, and patents, industrial designs come in at number 4, and they're sort of easy to forget about, especially in Canada where there just aren't that many cases. You guys have probably all heard about the Apple-Samsung fight that turned on an industrial design in the United States where it was hundreds of millions of dollars that were potentially involved. Then you come to Canada where industrial designs, there aren't very many high-profile cases, and it's easy to just forget that they exist. And it's also easy to think that, well, if you search, say, what industrial designs does Nintendo have, you'll see a bunch of registrations for sort of physical components, the hardware. And what industrial design is it protects the aesthetics of your product. Not like a patent that protects the functionality, but what you have is the industrial design, which is protecting what it looks like, what visual aspects appeal to consumers. And like I said, traditionally we've thought in terms of hardware, but a number of companies have been very innovative by using industrial designs to protect their UX and UI elements. And so one easy exercise to do would be go on the Canadian website for the Intellectual Property Office and see what Uber owns in terms of industrial designs. You'll see a number of digital designs using industrial designs not to protect anything physical, because Uber is not a hardware company, but you'll see how they protect elements of their app, the visual elements, using industrial designs. Industrial designs are like a copyright in that it tends to be sort of the creative aesthetic aspects of the product, but they're also like a patent in that it doesn't matter if someone copied you or not. Copyright, you've got to prove that the person had access to and copyrighted and copied from your work. So if they came up with the idea independently, you have absolutely no remedy against them in copyright. Whereas for a patent or industrial design, it's their problem if they didn't know that you had the patent or the industrial design. So industrial design is easy to forget about, but something that more and more companies are looking into, especially as they realize that it's not just for physical products, it's also for the digital ones.
Yeah, and I'll let you go into personality rights in a second, but just like to demonstrate the value of industrial design as an asset for technology companies, nothing to do with video games, but keep in mind that Apple probably won its biggest judgment on against Samsung in the telecom patent war based on their industrial design for the iPad. It was merely the configuration of the iPad that had been protected by industrial design, and they won one of their biggest judgments on that in Germany. And cool fact, the defendant in that case, Samsung, presented a device that was held by Captain James T. Kirk of the Starship Enterprise in the original series in the 60s as a defense to demonstrate that there was prior art that mapped on that particular industrial design for those Trekkies out there.
And so I believe that there's also a really interesting one. Allegedly, this is an urban legend in the IP community, allegedly a Donald Duck comic was once used in a patent fight. And it was an invention that was supposed to raise a ship by putting little buoyant balls into it, like if you have to raise a wrecked ship from the seabed. And apparently that had already been done in a Donald Duck comic. And the patent examiner actually cited that as prior art. And this is supposed to have happened in the Netherlands, and the records are allegedly lost. But it's one of those urban legends that seems like it's weird enough that it just might be true. Speaking of weird enough that it's actually true, personality and publicity rights in video games have been an exploding issue in the last couple of years. And these are the rights that celebrities, and depending on the country you're in, other people have to control any use of their name, their likeness, their voice. And that's been an issue specifically in video games for athletes. There have been some class actions in the United States. There have been suits involving tattoos on the athletes or on celebrities. We've all heard about the Mike Tyson tattoo case involving The Hangover 2. Similar issues have come up with tattoos in video games. And so we're not going to talk too much about this because it's not the kind of issue that typically shows up in a transaction and the kinds of software deals that we're going to be looking at. But it's something to keep in the back of your mind that if you're using a recognizable person in your game, there's another layer of rights you need to think about. Not the traditional kind that we associate with IP, but the personality and publicity rights that mean that you can't just use celebrities without their consent. And as we've seen, that's been, for example, the Lindsay Lohan case against Rockstar Games. Rockstar eventually won, but it's the kind of problem you want to avoid if you can. And it's hard to avoid a problem you don't know about in the first place. So now I'm going to, as you see, we've got a diagram on the screen that looks at essentially the typical deal structure in a video game transaction, the typical sort of publisher-developer deal. And we're going to see we've thrown in a third-party licensor here, far off on the right of the screen. And that's to basically make things a little bit more interesting because we're going to talk about the role that third parties can play in these transactions on top of the main publisher-developer dynamic. And we're also going to talk about where developers typically get their IP from because, as Jean-Nic mentioned, when you're looking to see who owns a particular piece of IP, you almost always go back to the person that came up with the idea, the person or the people who created the copyright or invented the patent. And then from there, you've got to move upwards, and hopefully you end up with a chain that traces from the person all the way to the developer. And then if you're the publisher, you hope that it traces back even further to you.
Yeah.
So I'm just going to put some numbers on the screen, and this is the order we're going to examine each of these links in. So you see at level 1 at the bottom of the screen, that's from the people who create the IP, or in the case of some sort of pre-existing IP like middleware that you might buy from a site, or say music, that pre-existing songs you're going to license for use in your games, getting from that level into the developer. So that's level 1, and we've labeled the 3 different sources A, B, and C because there are different concerns based on whether you're getting your IP from your employee or from a freelancer or independent contractor, and those are both new IP. So you imagine there it's some fresh code, you commissioned a song, you hired an artist, and then C is the example of, okay, the IP already exists and I'm going to the owner who's going to give me something, not that they created just for me, but something that's already out there and has been around for a while. Then we move up to the second level, and you see that we've got a double arrow between the publisher and the developer. And the reason for that is, well, IP tends to flow up into the developer at step 1. For publisher-developer relationships, there may be an exchange going both ways. The publisher may be licensing things to the developer will almost certainly be assigning or licensing IP to the publisher. And so that raises concerns on both sides about making sure that you've got the right IP ending up in the right entity and not accidentally moving something you didn't want to give away onto the other side's balance sheet. And then, as we said on the far right at step 3, we'll look at how a third-party licensor, like say a movie franchise, if you're doing a game tie-in to a movie or comic book or a novel series, how they can influence the dynamic, because they can often be just as important or even more important than the person on the other side of the bargaining table between the publisher and the developer. And so on that note, we're now going to zoom in on that first level, IP getting into the developer from one of the sources. And like we said, for employees and freelancers, those are sort of fresh IP, new IP, custom-made assets for your presentation, or presentation, for your video game. Or then on C, the differences that might exist when you're using, say, a song that was written back in the 60s that you need to set, say, the mood of your game. And so on that first step, employees. In some ways, employees are the easiest of the three categories from, say, a copyright perspective. In other ways, it's easy to overlook or to assume that rules for one type of IP are going to apply to the other types of IP. And so the main thing that we want to emphasize here is that the rules of what you own are slightly different depending on the type of IP. And because there are those differences in the rules, you always want to make sure you've got a very clear IP transfer clause in your employment contract. Like I said, let's start with copyright, where there's a little bit of flexibility. When it comes to copyright, employers are going to own any work created by the employee in the scope of their employment. So that's reassuring. It means if you don't have an employment agreement, if it's a verbal deal, if you had, say, a temp contract, the contract expired, but the person kept working there, you're still going to own what they create within the scope of their employment. But at the same time, the scope of employment can be a little ambiguous. Both because someone's role could evolve over time, and if the contract doesn't capture that, that can create ambiguities about who owns what, or because it's just really clear that the employee is going to create something that's normally not part of their job description. So to give an example, one of our clients, they were rebranding, and their CEO was an artist. He had a passion for graphic design, and their CEO drew the logo. CEO job description does not involve drawing logos. So that would be a case where the employment rule, the fact that you own what your employees create in the scope of their employment, would not help this company at all. They need to make sure their CEO signs a copyright assignment to ensure that they actually own copyright in their own logo. And that's something that's easy to overlook, easy to assume it's not going to be a problem. But you can imagine, what if, heaven forbid, the CEO got sick or died, or he left the company on bad terms. Suddenly, you don't own your own logo. You now have a third party owning copyright in your logo. You're in a lot of trouble, especially if, to use the last example, the CEO left on bad terms. So always, always, always have a clause in your employment agreements that specifically says, if you work here, the employer is going to own these kinds of IP. And essentially, you normally want this to say, we'll own all the IP you create at the job, for us, while on the job. And that's something that we're going to get into specific language later, but don't just rely on the employer rule. It's something you should have anyways, because as you'll see for the other types of IP that Jean-Nic will be talking about shortly, you need to have that provision in there anyways. There's no easy employer rule for patented inventions. And the last thing about copyright that you need to keep in mind is there's copyright, the economic rights that we've been talking about, the right to reproduce, the right to telecommunicate, all of the rights that allow you to exploit like a song or a video game or something like that. Then there's also moral rights, and those are a completely separate layer of rights. And they're rights that sort of look at the copyright not as an economic object to be bought and sold, but as an expression of the artist's personality, as sort of a work of art that needs to be protected, that has artistic integrity. And so those rights can never be sold away. You can't, if you have an assignment of copyright, the moral right, that won't change anything. The moral right remains with the artist. And you can have that moral right waived, so you can make the right go away, but you can't ever acquire it by a transfer. And so if you forget to include a moral rights waiver, you may own copyright, but your employee is going to own the moral rights to the work. And those moral rights allow them to control in important ways how the work is used. And Jean-Nic has what I think, it's not a video game example, but a very compelling example of what goes wrong if you forget about moral rights.
Yeah, true story. More on the consultant side, we'll get into that, but oftentimes, this is a true story on an issue that arises oftentimes, which is the creation of logos by third parties, where typically work is done on a statement of work basis. You get a bill for the work, you pay for the work, you get a new logo or a new website or something like that. In my example, the new logo was paid for by a multinational in the 60s. And the signs actually went up on buildings. The logo went up on buildings across the country. I'm not saying we see it from the office, but it's a sign that you'll see on buildings throughout the city and throughout. It's a logo that you'll see throughout the city and throughout Canada. Problem with not obtaining a waiver of moral rights is the author will say that truly that moral rights cover the integrity of the work, and that basically, if you want to modify the work, you need the consent of the author if you haven't obtained a waiver. So again, to come back to my story, multinational 30, 40 years later says, hey, you know what? It's time to jazz up our logo. They have someone jazz up the logo. They take down the logos on all the buildings in the country. They put up the new logo. And the author that had created the original logo in the 60s, who fortunately or unfortunately was still alive at the time, basically sent a demand letter saying, you know what, I created the logo in the 60s. I never waived my moral right. I have the right to the integrity of my work. You modified the logo without my permission. I want money. So the company comes to us and says, is that true? And ultimately, they ended up paying the guy some money. So there's actually real life example of moral rights affecting companies more on the technology side of things. We need to think of moral rights oftentimes in terms of artistic works, but you shouldn't. You need to obtain waiver of moral rights, as otherwise you'll have a bunch of individuals that worked on the game that might have created artwork, logos, that are still going to have rights and may eventually waive their moral rights for just more money.
Yeah, and just one thing to add to that is that moral rights, the kind of moral rights you have vary wildly throughout the world. So Canada, you have fairly strong rights, but you can waive them. In the US, almost no one gets moral rights. Very limited provisions in their Copyright Act that largely don't apply to the video game industry. Then you go to France, not only does everybody get moral rights, not only are they strong, but you can't waive them, and they last forever. And so there's a lot of, for example, films that were in black and white that have come out in colorized versions in North America, whereas in France they will never be released in colorized version because moral rights were raised. The sort of the successors, the people who inherited the moral rights said, we think this is destroying the artistic integrity of the original film. It was meant to be viewed in black and white. And so because these things last forever, in France there will never be a colorized version of some of these films. You can imagine there starts to get a parallel to the video game industry where you ask, what about ports, what about HD re-releases, HD remakes? That's, I think, a bit of a stretch, but someone may want to stretch their rights in that direction. And that's why having a moral rights waiver ensures there's only one person who can make decisions about how the video game is going to be used. Otherwise, you have two people with veto rights, the moral rights holder and the copyright holder. And having two people with veto rights over the same property rarely works out well for either side.
True. All right, the other right you got on your screen is patents. I'll broaden that a bit to inventions, and Michael is absolutely right. Typically, your assignment clause will capture those inventions that are either in line with the business of the company, created with equipment of the company, and so on and so forth. So you create sort of that universe of IP that you're assigning. We'll get to that when we review actual language. And again, to go back to like the original statutes behind your little monopolies granted by different IP laws, copyright, you go back to the individual. If he's an employee, the first owner of copyright will be the employer, except for the particular situations that Michael mentioned. If I go back to the individual inventor and I look at what happens if he or she makes an invention and what does the law says about ownership, it doesn't say much. It doesn't say anything. So you need to have actual, and that's why on the slide you got the reference to contractual ownership rights. You need to deal with these things contractually. Yes, there is case law that came up with a bunch of criteria that you can apply if you don't have a contract to determine who is the owner of the invention between the inventor and the company. We never want to go there. We want clear contractual language around these issues, and that's going to cover different things. It's going to cover, obviously, which is the same thing, by the way, for the other IP rights, but it's going to cover the fact that you need to communicate your invention to your employer. Then the employer has the sole right, obviously, to patent that invention. The employee assigns the invention, so communication, assignment. The employer is the only one that has the right to patent. And then there's always provisions around support down the road. And I'll give you a couple of examples for that. If you file for patent protection today, the first thing that's going to happen eventually down the road, and when I say down the road, it's in a few years, There's a civil servant that is paid to sort of punch holes in the monopoly you're requesting. That is called an examiner. That person is called a patent examiner, and the patent examiner looks at the patent application and typically, initially, will tell you there's nothing patentable in what you filed. That's the typical first response. So if you're the patent application owner, the person you need to go back to help defend your position in front of the patent office is the actual inventor, who may or may not be still in your employment. So you need to create sort of that obligation to support in the patent application process. Then you need the obligation to support during litigation. And litigation, I have an actual case right now in the famous Eastern District of Texas, where we're suing telcos for patent infringement on behalf of a client. And we're literally 15 years out after the grant of the patent. And your star witness is always going to be the inventor. So to protect, again, the scope of the patent, to protect the validity of the patent, so you need that person to be a witness in that case. So you will put in your contract the obligation to support for litigation purposes as well. Well, that sort of covers the ground that you need to address with respect to patent protection in your employment contract.
And so a lot of what Jean-Nic just said also applies equally to industrial designs, because we've seen industrial designs a little bit like a copyright and a little bit like a patent. You get it in the same way as a patent, and a lot of the rights are patent-like. Then what it protects tends to skew more towards the copyright side of the spectrum. There, it's a little bit more forgiving. There is an employer rule that basically says if you've paid someone to create something protected by industrial designs, you own it automatically. And then also on top of that, as with copyright, you don't want to take your chances by relying on that rule. You want to have something very clear in your contracts that says, by the way, here's a sort of an explanation of everything that we own, and sort of you've got confirmation that that belongs to the company. And then just sort of as we've gone over these three key areas about how to own what you say you own, the last thing we'd mention is just on a practical level, a lot of video game company employees will have side projects or will want to maybe develop something on the side. And it's important to have a clear policy on that, just so your employees aren't asking themselves questions, aren't wondering what they can or can't do on their own time, on work time. Can they reuse anything at all from work? Just have a policy on that. I'd say the strictness of the policy often depends on the employee's involvement, their level in the hierarchy, and the size of the company. But that's something that, I mean, there's not that many side projects for, say, people who work in certain other industries. But because video games is a creative industry, often your employees will have side projects. And that's something you, again, should have clear rules on. It's almost less important what those rules are, just the fact that they're there, so that no one's sort of asking themselves questions about that. Now, moving from employees to freelancers, this is where things start to get a little more complicated, a little more tricky to navigate, because especially in the copyright world, but also with respect to the other types of IP, things aren't quite as clear, not quite as easy. So before we get into the three different types of IP that we're going to talk about now, the first point we want to make is as soon as you go to a freelancer, as soon as you go outside your own corporation, there's going to be the question of who are you dealing with. Is it a person, or does that person themselves have their own corporation? That's important because, as we've said, IP almost always traces back to the person who came up with it. And so if you're doing business with a freelancer, but that freelancer has a corporation, and you sign with the corporation, you may or may not acquire the IP. You're sort of relying on the freelancer to have correctly put the IP into the corporation, so then the corporation can give it to you. And one of the problems is people forget to do that. They think of the corporation as sort of a mirror image of themselves, as their alter ego, so they never bother assigning the IP. And we actually saw that in a recent Canadian copyright case. It was called Harmony Shipping, went through the federal court system, gets all the way to the Federal Court of Appeal, and the guy who came up with the software program had created a business, and he never assigned copyright and software to his own business. He tried to say at trial, well, I had a mental assignment. I thought about it. I mentally transferred it from myself as me to myself as corporation.
Yeah.
That went nowhere. And that was one of many reasons he lost the case. But that's the kind of thing that can happen for people who are not thinking about IP ahead of time. You sign with the corporation, but has the corporation signed with itself, with its own owner? A lot of people forget to do that because they think of themselves as just a mirror image, but you're not. You're two separate people.
Yeah. And one quick note on that, Michael, as well. Especially for the non-lawyers in the audience, what we see oftentimes is people are just going to go on the web and they're going to get a template IP assignment form. And those template assignment forms, and honestly, even our template assignment form that we give to startups, for example, will cover the employee, the intern, the freelancer, the consultant, the subcontractors. It's like it's a one form that can be applied to all of that. The issue with that is those forms typically are for individuals. So the form will say the person, whatever you're going to call it, the participant, or whatever you're going to define as the term to represent the individual, waives his or her moral rights. But the moment the freelancer is a corporation, as Michael said, the corporation does not own moral rights. So you're going to have to deal with that aspect differently in a contract with a corporation. So the corporate, you need to make sure, yes, that the corporation owns the IP, but then you'll need to make sure that the corporation has obtained moral rights. If it's a one-person show, it's not the end of the world. You can have the person intervene to the contract, waive his or her moral rights, and you're good to go. If it's a consultant company that has, let's say, 10 individuals working for them, that might be a bit harder. So worst case scenario, you can always obtain a warranty that the employees have waived their moral rights. But one thing to be sure, you need to deal with that differently if it's a company versus an individual, and be very wary of the templates you're going to find online.
Yeah, and that's our preferred approach, is when you can do that, have the individual intervene in the contract just for one or two key clauses, typically the IP transfer and the waiver of moral rights. And that way you basically pierce through the corporation to the underlying IP creator, the person, and that person's only part of the contract so that you can make sure that you have ironclad IP ownership. So that's the ideal way to set it up. Less ideal ways are to rely on a promise by the corporation, a warranty that, yes, we promise that we've set everything up correctly. But if that promise turns out to be untrue, you don't own the IP then. You may have a claim against the corporation because their warranty is false, but the IP remains with the original owner. So the ideal thing, and it's easier to do with a one-person corporation or a small corporation, is to have direct interventions. Where that's not possible, you have to balance the risks and decide how you want to proceed. So now stepping into copyright, there is no rule, no equivalent to the employee rule when it comes to freelancers. Just because you hired someone to create a copyrighted work or just because you paid for it doesn't mean you own it. So you actually have to be very careful, and you have to make sure that there's ownership language when it comes to copyright. As Jean-Nic said, if these things are done with statements of work, purchase orders, and invoices, those kinds of documents rarely say anything about who owns what, and on their own, they're not going to get you copyright ownership. And so that's one of the absolutely key takeaways here, is that if you're dealing with a freelancer, with an independent contractor, a consultant, whatever, you need something in writing, and it has to say that you own copyright.
Yeah.
Because a verbal copyright assignment does not work. That sort of a handshake deal, an oral deal, well, I paid for it, all of those arguments get you nowhere in terms of owning your Canadian copyright. You have to have something in writing that says that you own it. And that's sort of the main takeaway. When it comes to the arrow that we showed for freelancers, arrow 1B, make sure it's in writing and make sure it says you own it. Same question about moral rights waivers. Again, you need to make sure that they're in there to make sure that you're the only person who has a control over what can or can't be done with the work. Otherwise, you run into the problem we discussed before of two people with veto rights, which is never the kind of scenario that a business wants to be in. The next point that I would say is that music, so we're going to slow down briefly and focus on music, because music has a lot of strange particularities from both a legal and a business perspective. And so when you use music in games, you need to be aware of those particularities. The first thing is that copyright in music, you've got multiple layers of rights. You have copyright in the song, so sort of when you think of the song as sheet music lyrics, that's one level of copyright. But then below that, you have rights in the particular performance or recording of the song. So if you have, say, a Beatles song, like A Hard Day's Night, you have the original sound recording by the Beatles, and then if someone does a cover, it's a separate right, a separate sound recording copyright, both under the umbrella of the original song. And so if I want to use a particular recording, whether it's the Beatles' original recording or the cover, I need to talk to the person who owns that copyright in that recording. I also need to talk to the person who owns copyright in the song. But on the other hand, if I'm going to record my own original version, I'm going to do my own cover of it, the only person I need to talk to is the copyright owner of the song, because I'm not using a specific recording, I'm using just the song itself. So that's sort of a layering quality that shows up only in music and that it's easy to forget about. That if it's pre-existing music, you have a second person you need to talk to, and that can extend all the way to all the performers on the track. Typically, the producer is going to control all of the rights in the track, so normally there's just one person to talk to. But again, if the producer didn't set things up correctly, all of the performers on the track have their own set of rights, which gives you another group of people you need to negotiate with. And that complexity is one of the reasons why you have dedicated copyright clearance agencies in the music business. That depending on what the song was, depending on when it was recorded, how many people are on the track, how carefully the rights were set up at the time, there can be anywhere from 1 to about 14 owners for some tracks. You can think of large bands that went through multiple changes in ownership. It can get very complicated very fast to use pre-existing music. And that's one of the reasons why most video games you compose new music. Because if you're starting fresh, you don't need to worry about who owns what. You don't have to navigate those complexities. But, and this is again why music is complicated no matter how you approach it, one of the things you need to know about the music business is that almost all of the composers, almost all of the performers you're going to deal with have already joined up with copyright societies, which are basically groups of copyright owners who get together, pool all of their rights, and give it to a management group that's going to collect royalties whenever their songs are played on the radio, used on online music services, et cetera, et cetera. So a lot of these societies, the way they're set up is when a performer or a musician or a composer joins, they give all of their copyrights forever, now, future, every single copyright, no matter what, to the society. That means if you try to hire this person to compose music for you, they can't give you copyright. You can put whatever language you want in the contract, but it's too late. They already gave all their copyrights away to the Copyright Society. So one of the things you need to ask the performers, one of the things you want to check in on is what groups have they joined? Some of these groups are more flexible than others, but especially in Canada, for groups like SOCAN, which owns pretty much all of the music you're going to hear on the radio, they already have full ownership of all of the performance rights in that music. And so if you have a deal with a SOCAN member to write a contract or write a song for you, you can't own copyright. It's too late. Copyright already belongs to SOCAN. So whatever kind of deal you strike is subject to SOCAN's prior rights. So that's why even when you hire someone to compose your music, you need to worry about whether they own what they say they own, because they may not have any rights to give you because of the decisions they made 5-10 years ago when they signed up to one of these groups. And so that's the tricky bit with music. You're sort of damned if you do, damned if you don't. New music, you have this problem, this challenge of a lot of the sort of the big name and more prominent performers have already signed away their rights. Or if you use pre-existing music, you have to go through often very complicated clearance systems. And so that's the music business in a nutshell. There's even more complexity we don't have time to get into, but just be aware that of all the different types of copyright, music raises unique challenges. And it's easiest to get around those challenges by commissioning new music, but you got to make sure who's on the other side of the table and what societies they've already joined. And so the last thing I'm going to say on copyright before turning it over to Jean-Nic to discuss patents is a question of U.S. law. And this is an important point for Canadians. It's a small point, but the U.S. has what they call the work-for-hire doctrine, which is this idea that certain kinds of works, if they're commissioned, so we talked about how Canadians, if you commission copyrighted work, you don't necessarily own it. You need language that says you own it. The U.S. have a slightly different approach. They say if you commission and pay for work, if it's certain types of work, which and those types cover most of the things you're going to need for video games, and if you've agreed that this is a work made for hire, not only does the person who commissioned the work own it, which is always good, but we're going to exclude certain buyback rights that exist under U.S. law. These buyback rights are really important because this is the only way to avoid having them apply to your work is through the work-for-hire doctrine. So if you want to keep the work within your control for its entire lifespan, a Canadian needs a work-for-hire clause. Because without a work-for-hire clause, someone is allowed to get back or retake control of their U.S. copyrights. Now, how does that work? We're going to go over that regime just to sort of explain why it's important, why you should care about work-for-hire clauses. The U.S. regime for buybacks, or buybacks maybe not the right word, it's actually just a pure termination right. It basically says starting 35 years after you've made your initial copyright agreement, the creator can end the transfer. So, and they can end it anywhere from the 35th year to the 40th year. and then they retake control of their copyrights, no matter what. You can't waive that right. That right exists. They will always have the option to terminate between the 35th and the 40th year. There's some conditions around that. You have to give notice, et cetera, et cetera. But the point is, 35 to 40 years, your US copyrights become vulnerable, except if you have a work for hire clause. And the reason that you're probably thinking, and it's a reasonable thought, well, video games, things change fast, tech changes fast. There's no way that 35 to 40-year-old code matters anymore. Yes and no. When you think about certain very popular franchises, take the Mario franchise, for example. Super Mario Brothers, 1985, that 35th year, that key termination date is 2020. Mario is still going very strong. Everything from the character himself to some of the design elements of the levels to the iconic theme music of the first stage. All of those elements would be up for grabs starting in 2020 and would still be very valuable commercial properties. So there's other video game franchises that exist now that we can think of continuing well into the future. I mean, take a look at Assassin's Creed. That is one of those perennial franchises that who knows how long that will last. That could be valuable well into the 35th or 40th year after it was created. And without a work for hire clause, the original leads, the original creators would be able to take back their US copyrights. So this is not a hypothetical. It's something you really want to plan for, because if you are wildly successful, if you do create the next Mario, you want to make sure that that is going to be yours forever and that you aren't vulnerable to losing that sometime in the future. And the only way to do that from a US law perspective is to include a work for hire clause.
Yeah, just maybe one more point on that, Michael. Again, for those of you who are going to go online to grab an IP assignment form, if it's a US form, you'll probably have the work for hire clause. If it's a US form, it might be weak on the moral rights front because of what Michael said. If you find a Canadian assignment form, there's probably, it might be okay on the moral rights front because it's more of a Canadian concept, but there's not going to be any mention of the work for hire clause that Michael mentioned. And you might be thinking, yeah, but you know, we're based in Montreal, our employees are in Montreal, or our consultants are in Montreal. I mean, who cares? I'm getting the assignment, I'm in Canada, it's Canadian law that applies to that. So our advice is never take those chances. That if it's a US copyright issue, so if you don't have the work for hire language in your Canadian template, that might affect your US copyright down the road. So we always include work for hire language in our templates for consultants, for sure.
Yeah.
Even if everyone is in Canada.
Oh, and I should say the U.S. work for hire doctrine also covers works created by employees. So theoretically, you don't need to include that in your employment agreements. It's, as Jean-Nic said, just for consultants. But often there's no harm to throw it in, make all your templates consistent, put that work for hire clause in each of them.
Which is exactly what we do. On the patent side, not much to add to what I said, as there's nothing specific in the law. If you want an assignment of the rights in inventions, including the right to file for patent protection, you need to have clear language with respect to that. If you're only getting, sometimes there'll be funky language around that. You're getting an assignment of the deliverable, and the deliverable is some piece of art or whatever. And there's no clear description on what kind of underlying IP you're actually obtaining, then make sure that you're getting some sort of exhaustion clause, something along the lines of, you can use that, and we're gonna covenant not to sue you for any kind of infringement. But in an ideal world, if you want to own what the freelancer has done, you need pretty much the exact same language that I mentioned before. Communication of the invention, clear assignment of the invention, anything that was done for the company, with the company equipment, related to the company's business, so on and so forth. You'll need the same kind of clauses as discussed before.
And so, again, industrial design's much the same story as patents for this slide. Very little to add, except that for once there's sort of a client right. There's an ownership right that you get because you paid for something. So it's not like copyright in that extent. Industrial designs are a little bit more forgiving. But again, as with patents, we recommend have the clear language there. It never hurts to have clear language. And with that, we're going to take a look at some of the language, and Jean-Nic's going to provide his comments on it. Just for note, both of these quotations are taken from actual judgments. One from the Ontario Court of Appeal, which is the first one, and then the other one from the Federal Court of Appeal. And in that case, the Federal Court of Appeal case was Quebec civil law. So you've got sort of two examples translated into English in the second case, covering both of Canada's major legal systems.
Yeah, I mean, what you got on the board is actually quite clear. To tell you the truth, I'm not very fond of the second example, in the sense that about 90% of my work is with high growth emerging technology companies that go through multiple rounds of financing. So obviously multiple due diligence by IP lawyer, and then that are acquired, and I've done acquisitions with the Microsofts of this world and so on and so forth. And the IP lawyers in due diligence, they like the first clause. They like clear assignment language. So just in terms of making your life easy, I would go with clause A. Really like assign, sells, transfers. You want that kind of language. And then you need to define. So the rest is one example, but you will need to define, as we've said on different occasions before, like the pool or the universe of IP that actually will be assigned. So again, assign, sells, transfer, anything, work, inventions, ideas, concepts, know-how, whatever. You typically define the pool of IP that is covered, that either relates to the business, done with the company's equipment, alone, or with others. So you're sort of defining that universe with a clear assignment language. And where you gotta be careful, which we have not mentioned before, you gotta be careful with the background IP. So individuals come to you, they have a past, they've generated IP in the past, and typically your contract language will deal with that past IP somehow, somewhere. As Michael mentioned, sometimes people have projects on the side, so they are generating IP either on the side or before. And typically you'll deal with that. You'll either say that you're not onboarding any background IP, or you'll need to give sort of a short description of your background IP, and then say that if you're not going to bring it, and if you do bring it, you give a license to the company so that there's no issue with the background IP. So you need to deal with that as well, especially in a context where people have generated a lot of IP in their past. But preference to the first clause at my end, Michael.
I'm going to follow Jean-Nic on this. As he said, one of the things you need to think about is not just how well does this contract work for me, but if you're doing business with investors, financiers, or other third parties, what will they think when they review it? If you're planning to exit your company, if you're planning to get partners or financing with third parties, you got to think about, if it works for me, I may be willing to take clause B, but if I know I'm going to be showing this contract to very picky people with very big teams of lawyers, go with clause A, because, hey, assigns, sells, and transfers. Okay, it's a little redundant. You've got three words that say something very similar, but if that's the language that the other side's lawyers are looking for, you're saving yourself a lot of trouble by going with that.
Yeah, and always keep in mind, I mean, I love the own what you say you own kind of title, because it really comes down to this, the kind of language you're using to demonstrate that you own the IP underlying your technology. And it might be that you'll never have to demonstrate that until you find a publisher or until you sell your game. So there might never be an issue. You've never used that language. You've actually never had a contract, but you're building your tech. You have a slide deck that says, this is my game, this is our tech, whatever it is. And you've never had to demonstrate that. But one day, when you find a publisher or when you sell your company, I love the car analogy. Someone's going to pop the hood and look at what's going on in there. And if you haven't done this in that kind of way, you'll get issues down the road. I actually, for an M&A transaction, I was the first one to pop the hood after 10 years for a tech company that never raised financing, never had any issues, but now they were on the market for an M&A transaction with investment bankers. So we figured we'll pop the hood first before due diligence, and we needed to go back about 10 years and modify contracts that had either modify or generate contracts depending on the issue. So keep that in mind. Even if you say, you know what, we're not going to raise financing, still worth it to do it properly.
Yeah, and maybe two other examples where it's important to do it right from the start would be privacy and open source. We're sort of drifting away from IP ownership, but just to be aware that those are two things that are easy to fix up front, hard to fix after the fact. And so if you have good practices from the beginning, that will save you just an ocean of trouble in the long run. On privacy, set up your privacy policy well. If you're thinking of being at all associated with Europe, there's GDPR. We're actually going to have a video game and GDPR presentation next month with one of our colleagues who's a European lawyer and who's therefore one of the few people in Canada who can speak to the GDPR effectively. And then on top of that, this issue of open source, of tracking, and maybe I'll let Jean-Nic, you've had a lot more experience with that.
Well, it's tracking and it's obviously documenting, because when someone pops the hood, what happens is popping the hood means send us a list of the open source components that you're using. And if you're not able to do that, it might be an issue. So it's actual policy around open source, and then it's documenting your usage. And making sure you understand the licensing language in the open source license. In the development front, typically there's no issues. If you're incorporating open source in your game, there might be an issue depending on the licensing language. Don't forget, I'm going back to one of the things I originally said. A license is basically and only a permission that someone is giving you to do certain things with their little monopoly, but it always comes with strings attached. And those strings might create issues or might not. In due diligence, I saw an open source license recently that is the beer aware license. And the string that is attached to the permission. So you got to permit the permission to use a source code. No worries, use it, do whatever you want with it. The string that comes with it is, if this is my name, if my code is useful and you ever see me anywhere in the world, you got to pay me a beer. So it's the beer aware license. But as you're all aware, there's other licenses that are going to say that if you incorporate the work, you modify it, you redistribute the work, the source code or the object code with your own code, then you need to open everything, even what you thought was proprietary code, in the same manner as the open source that you use. So that string is a bit different, obviously, than the beer aware license. So just be aware of that, have an open source policy, document it. The example that I love to give, we sold a startup to Microsoft a couple of years ago. One of the first questions in due diligence was send us a list of your open source components. And the client said, sure, give us 10 minutes, we'll just get the list and we'll send it to you. We update it regularly. We have a policy, it's always updated. We audit our own code. And the acquirer was extremely impressed, and that always keeps the level of confidence super high in your transaction, which ultimately is what you want as a lawyer. You don't want the law to get in the way of the confidence that was built between the teams.
Yeah, and so on that note, we're going to take a look at pre-existing content, which could include open source. There it's going to be, as we said, it's going to be a license. The person who came up with the open source isn't going to give you ownership of the copyright in their code. Instead, they're going to give you permission to use it. And so that's the big difference between a license and an assignment. A license is permission to use, but the person who gives you the license retains ownership. And we're all familiar with this with the software that we install on our personal computers. We only have a license to it. The original owner, whether it's Microsoft, whether it's EA, whether it's Ubisoft, they all maintain ownership of the copyright. Versus, on the other hand, assignment, which is sort of the fancy legal term for purchasing or getting a transfer of ownership in some intangible right. So it's exactly like a sale. Just as you buy and sell physical things, you take an assignment of intangible rights like IP. And so when you are dealing with pre-existing content, odds are you're not going to get an assignment. It already exists. The person probably is planning to license it to other people, so the best you're going to get is a license. And maybe you can make an exclusive license, which is sort of a kind of super license halfway between mere permission and actual ownership. An exclusive license means that you're the only one who can use this in a particular defined field. So you might have an engine where you're going to license the engine and you're going to try to negotiate an exclusive license. So your game will be, say, the only first-person shooter that's going to be using that license in the market, or it'll be the only racing game, or the only game released in North America, or whatever. And that's an example where you can use sort of a hybrid approach that even if you don't own it, the other person's not going to sell you their engine entirely, at least you have some measure of accessibility or of exclusivity. But keep that in mind, that the other main difference between licenses and assignment is if I own something, I don't need the contract to spell out what I can do with it because I own it. I can do whatever I want. But if we're in the field of licenses, if we're in the field of permissions, it becomes a lot more important to be detailed about what I can or can't do. Because anything that I don't have permission to do, I'm not allowed to do it. Because if I own it, I have this sort of residual, anything I want to do, I can do. No need to spell out verbs or anything like that. On the licensing side, it does become much more important to be detailed, much more important to foresee the different uses, the different markets. Is there an issue with evolving technology? That's where you need to be very careful. That the license does not have the sort of the comfort of, well, anything that's not listed belongs to me because I own it. License, it better all be there black and white on the page. And related to that, the issue of representations and warranties comes into, if you are licensing something and it's pre-existing content, how do you know that everything has been set up correctly? How do you know the person who says they're going to give you the license actually owns it? You want to own what you say you own, and you also hope that the people you're dealing with, that they actually own what they say they own. And there's been a sort of a cottage industry in Canada recently with those copyright societies we told you about. People have started to pop the hood in litigation against them and say, okay, you claim you own all the popular music in Canada. Is that true? And so we've been seeing deficiency rates in their chains of title that range from about 5% to 30%, to in one case it was alleged that they didn't own anything that they claimed that was within their repertoire of copyrighted works. And so that's creating problems where people were licensing from them thinking that that was the only person they needed to do business with, and that wasn't always the case. So there you want to make sure you have a representation and warranty that say, I guarantee that I own what I'm licensing you. You know, if it's a song, I guarantee you that I own the rights to this song in Canada. And if someone's not willing to give you that kind of representation and warranty, if they're not willing to back up their ownership of the work, don't do business with them. Because if that's something they're not willing to commit to, that's a huge red flag. One of the issues is you got to make sure that they own it, and if they're not willing to back that with some kind of consequence, you probably should walk away from that deal. And then, as we say, the next point, the way you sort of implement that is what's called indemnification. This idea that if I incur costs because what you've represented, warranted, what you've guaranteed isn't true, you're going to make me whole. You're going to sort of act like an insurer and pay any expenses or damages or claims that I have to deal with. So in the music example, maybe you get a license for a piece of music, then someone shows up and says, actually, they don't own it, I own it, I want $5,000 for this song. Then you turn back to your original licensor and say, well, you told me you owned it, I just incurred $5,000 in costs because that isn't true, you owe me $5,000. And if you have a well-drafted contract, that should be something that's very easy to handle. They either prove that they own it, or if they can't, they have to hand over the cash. And again, if they're not willing to agree to that kind of approach, there's something wrong, and you've got to think very hard about whether you want to do business with them. One other issue about sort of owning what you say you own is how do you deal with moral rights issues? We already alluded to the fact that a company doesn't own the moral rights, so it can't waive on its own behalf. You have the issue with the people underneath the company, the ones who actually wrote the song, wrote the code, came up with the character. They're the ones who have to waive the moral rights. One advantage in Canada is that if they have waived, you get an automatic flow-through from the person who owns the copyright through to you. And that flow-through doesn't have to be in the contract. So it's as long as there is a waiver somewhere, you're fine. It's nice to put it in to confirm that it would flow through to you, but it's not something you have to have just because Canadian law has made it easy that once there's a waiver, unless there's special conditions or strings attached to that waiver, it'll flow through the entire chain from the original owner to the owner's employer to licensees like you. And then once again, just to emphasize the special case of music, which is, as we've said, these copyright societies, they're often the ones who got there first. They often own the song that you want to use no matter how you get it. And you got to make sure that you talk to the right people. There's that issue of nested rights. Normally, if you're going after a pre-existing song, it's not because you want to make your own cover. Normally, it's because you want to use a specific rendition of that song, either because it helps set the mood in a historical game, like if you're doing a Vietnam War game, or because it has exactly the right sort of emotional appeal for what you're trying to do with your game. And so there, just always make sure you talk to all the people involved. And like we said, that's the song owner, but then also if you want a specific recording, the people who control that recording and whose names are on the track. Again, this is why there's specialized music clearance agencies. It's a pain in the butt, and they're the ones who will do that work for you. And so on that note, we're going to have a brief digression about trademarks.
All right, cool. Let's do it. A couple of elements to think about when you think about trademarks. Trademarks basically are the distinctive features of whatever you're putting on the market. So typically it's a word, Google, Kodak, whatever. So it's your game name. It might be the studio name. It is logos as well. Logos typically are protected both as trademarks and through copyright, thus the waiver of moral rights we've discussed before. A sound, I think it's the Intel sound that was...
Intel, and then that's one of the recent ones. There's also the Roaring Lion for, I believe it's MGM. That was one of the first sound marks. They say when you're in a movie theater, you hear a lion roaring, you think about us.
Yeah.
There aren't that many sound marks. They're a little more exotic, but the ones that are there are usually buried somewhere in our subconscious.
Product packaging, shapes. In my younger years, the example that was always given was the UPS truck shape. Not sure about their newer trucks, but in the olden days, the shape of the UPS trucks was protected as a trademark, as well as the Perrier little green bottle.
And you're probably thinking we don't sell video games in boxes anymore. Why have they put that on the screen? Everything's digital. Or they're in the standardized plastic packages. And the issue there is, think about special edition games, the kinds of like the kind you want to unbox, and that have very elaborate packaging. You may, depending on how many you have, depending whether you're going to reuse that format of packaging for the sequel, you may want to look into trademarking that, because that's an example where the package has immense value to the customer, and that's how you distinguish your particular special edition from all the other special editions they could buy. It actually is the package.
There you go. A couple of points to think about on trademarks. You need to you need to look at trademarks from two perspectives. Your ability to use it, obviously, and your ability to protect it, should you want to go down that path. I want to start with the ability to use. If you're selecting a name for a game, for example, and obviously, as the case with all of our tech clients, actually, your market is not Laval. I mean, it is Laval, and it is Montreal, and it is the South Shore of Montreal, but it's mostly the world. So you need to be careful that someone out there doesn't have already a registered trademark, that when you start marketing your game, you create some sort of web presence or whatever, you start marketing your game, putting it out there somehow, somewhere, social media, internet, whatever. You don't want someone to start throwing rocks at you, and by that I mean sending lawyer letters from wherever in the world. I have received, or clients have received, demand letters in the tech space I have real examples of letters received from Berlin, Chicago, for startups that just launched their products, and wabang, they were shut down in the sense that they needed to rebrand. And rebranding, when you're trying to build something new and to launch it, is never a good idea. So the first thing, and typically our clients tell us two things that are wrong. So bear that in mind. Well, Jean-Nic, it's part of our corporate name, and Industrie Canada gave it to us. We got this nuance report. If you don't know what it is, forget about it. It's irrelevant in this context. Just keep that in mind. We got this nuance report that shows that we can get it as a corporate name, and the brand that we're using is part of our corporate name. Therefore, I can use it. Completely wrong. So forget about that. And Jean-Nic, we did a Google search. We looked at domain names. Yeah, we're good to go. There's nothing out there really similar. So that's a good start. But as it says at the bottom of the slide, don't stop at the Google results. It's a good start. What we have all our tech clients do, including in the gaming industry, is go through the American trademark database, the European trademark database, and the Canadian trademark database. Why only those three jurisdictions? They're easy to play with, and it's, from a risk or statistical perspective, it's going to give you a good idea of what's out there. And if you want the links, send us an email. We have the links. We'll send you the links. and go through those databases. And what you're looking for is anything that's confusingly similar. So, you're going to have to play with the words just to make sure that you're dealing with similar concepts or phonetical equivalents. You do need to play with that. You're looking for similar words, identical words, in the same space or in a similar space, because what you're trying to assess at the end of the day, without being, I don't want people here to become trademarks agents, but what you're trying to determine is really when Michael as a consumer sees product A and then product B with a similar trademark, is he gonna think that they all come from the same source? And that's the only question. So 2 divisions from the same company, 2 games from the same company. That's the ultimate question. Are you confused into thinking that they come from the same source? So you got to try and make your own determination with respect to that. And you might be surprised. I have a client that by doing that exercise went to 3 different brands before ultimately telling us, you know what, the 4th one, we didn't find anything. And then what we do typically is we'll do our own search, which obviously costs money, just because the software that we use do assess the phonetical equivalencies and all of that. So we have specialized software that do these kind of things. And just to confirm, but at least you're only going to do that once. You're not going to do that 4 times. So that's super important. Go through the databases just to make sure that you can use the trademark, that no one has a registered trademark. And then the question becomes, okay, in everything that we mentioned, the shape of product packaging, the shape, the sounds, the logos, the names, do we need to get an actual registration, and why? The registration really is the only piece of paper that gives you a monopoly coast to coast in Canada or in the US or in Europe. So these rights are territorial, and it's only the registration that gives you the exclusivity. If you don't register in Canada, it's a bit complicated. You got to go where the defendant is, or is using the trademark, demonstrate that you have goodwill in that specific geographical area. It's really complex. You may not want to go there. You may want to register the trademark. And then you just try to figure of all the distinctive elements that you have, which one is the most valuable asset, and probably register that. Be wary of registering logos in the sense that if you register a logo, it's the logo as actually registered that on which you have the monopoly. If you change it, if you jazz it up 2, 3 years, 4 years down the road, you know what, the market didn't respond that well to the logo, we're going to change it. It's possible, if not even probable, that jazzed up logo will not be covered by the initial registration, so you just got to be careful about that.
Yeah, and just to amplify that point on logos, a lot of the times we'll see companies represented by other firms always filing a logo and a name at the same time. That shouldn't necessarily be automatic. You need to think about your logo. Will you update your logo? Are you absolutely sure there will be no change to this logo is it something that's going to be used as frequently as the name? The name rarely changes once you've committed to it. Logos tend to get updated over time, and so whether the logo is worth the investment of your money, you need to think about. It should not be just automatic, because otherwise you're basically doubling your trademark costs for potentially very little value.
Yeah.
And so on that note, one piece of the trademark puzzle that we should get into is we've been speaking mostly about the product itself, ownership of IP over the product, the copyright, the patents, the industrial designs. Trademarks are the one thing that give you branding power, that look at not what the product is, but how the product's being sold, what tells consumers about the source of the product. So that's, in many ways, trademarks are very different from the other IP rights. They have nothing to do with the product. You could change the software completely, slap the same trademark on it, that still works. And so trademarks protect things like, in practice, trying to get domain names. Trademarks are the only way that you could try to seize some domain cyber squatter's domain name. So if you want to have that kind of control, you need a registered trademark somewhere in the world. Similarly, a lot of the platforms ranging from Twitter to Alibaba to YouTube have trademark policies. These aren't like, this isn't the law. There's nothing in the trademark laws of any country that requires them to do this. But a lot of them as sort of good corporate citizens and to avoid problems going forward, if you have a registered trademark, you get certain rights relative to the platform. They may, and these policies could change, But the last time I checked, Twitter would give you an inactive account if you had a trademark that shows up in the account name. YouTube would close down accounts that have questionable content if they, again, are using an account name similar to your trademark. These policies are all subject to change because they're just policies, but that's an example of sort of a non-legal benefit to having a trademark. They get you some leverage, they get you some additional rights on various kinds of platforms. Now, we're sort of coming into the core interface, the core IP interface that this presentation has been building towards. As we've seen, okay, let's assume the developer has everything they need in terms of IP rights. That was step one, A, B, and C. Now let's go to step two, the publisher-developer interface. What does each side own? What should each side own? And how can they make sure that those rights end up at the right entity at the end of the day with the deal? And so first thing we're going to talk about here in the developer-publisher contract is this issue of foreground and background IP. That was something Jean-Nic had spoken to earlier in the sort of with employees who've done work in the background. In the context of developers and publishers, foreground IP refers to the IP you've created specifically for this transaction, the new stuff, the fresh code, the unique characters, new music, new art assets, animations, cutscenes, movies, everything. Everything that's new and specific to this project. Whereas background IP, that refers to all the sort of tech and tools, like an engine or something that you've developed in-house, that you're going to use not just in this project, but maybe in other projects. And one of the things that is very important here is a lot of the contracts that come to you as a first draft from the publisher will say, we own everything in the game. That, you need to say, whoa, slow down there, let's nuance this. I'm happy to let you own everything that's foreground IP. Everything new that I've developed just for you belongs to you, not a problem. But I've got all my other tools that I didn't create for you that I use in all my games, and there's no way I'm going to transfer that to you. And so that's one of the most important things to look at. As soon as you get the publisher contract, you take a look and you say, is this so wide that they would get my background IP? Because there's basically no legitimate business reason for a business to ever give up its background IP. It prevents them from using it, so they should always make sure that they maintain ownership of the background IP. Only give up the foreground.
And Michael, just one point on that. This is fundamental because all of these contracts that you're entering into, if the company's ever acquired, they become what we like to call existing encumbrances. Mm. And you're going to want to, so you're telling the potential acquirer, this is what we own. This is what we own. And the acquirer says, you know what, because of the assets that you own, we're giving this price tag to the company. But then they dig through existing encumbrances, those existing contracts, and they're going to say, you know what, you told us that you owned these assets, but they're completely encumbered in the sense that your tools are licensed. Oh, no, they weren't licensed. We only licensed that. Well, not when you're actually looking at the language. The language sort of scoops in that background IP, which might be the core assets or some of the core assets of your company. So you've got to be very careful as to how you craft language around that background IP that is not like directly directed to the game. Mm-hmm.
And so that because of that, this is a very negotiated provision in a lot of these agreements. Publishers, they do have legitimate concerns to make sure that they have the right kind of rights over background IP. And so the issue is sort of balancing concerns to make sure there's no publisher overreach, but at the same time they have what they need. And normally what the publisher needs is a license, that you license the background IP and then you assign or transfer over the foreground IP.
Yeah. And that license needs to have those, very precise boundaries as you've mentioned before.
And the other thing you can do with the license component is that depending on the circumstances, you could consider if it makes business sense and if it's narrow, you could make it an exclusive license. Like let's say you have an engine that's really good at doing bullet time, and you have a publisher and they want to use your engine to make a racing game, and they want to be the only racing game that has bullet time for cars. Okay, sure, maybe you could agree to make that license exclusive because it's a relatively narrow slice of the market. On the other hand, if you've got a publisher who's doing a first-person shooter, bullet time is a very popular mechanic for first-person shooters. You would never give an exclusive license for that because that would be the main market in which you're going to be using an engine that's good at bullet time. So again, this is a question of some kind of license, but how strict is it? How do you define it? That very much comes down to the business side of the deal, looking at what kind of technology, who am I licensing it to? If I am, perhaps they're willing to pay me a lot to get some of my background IP on an exclusive basis. And that's some place where we can give you the legal possibilities, but what what deal you should ultimately accept is going to be driven by the business rather than the legal options. You just want to make sure that whatever you do, you know what you're getting into, that you're not accidentally giving away your own tech and tools. And so that sort of covers off foreground and background IP, but that's the point we made in early with level 1 was get it in writing and make it clear. The point we want to hammer home here in step 2 is really pay attention to foreground and background IP. It's really the fundamental and one of the things that's easiest to overlook.
Yeah.
And so related to that, as we've seen this issue of representations and warranties, when you're at the developer publisher level, there may be a team of 80 people working on the game. It could be even more for larger games. What do you do to make sure that all of those people have assigned correctly to the developer so that the developer can then in turn assign IP ownership to the publisher? A couple of ways you can do that. I'd say the most common way is simply you take it on faith. You have them promise that, yes, we've set everything up correctly. These people have waived their moral rights. They've assigned their copyright to us. And that's basically just a promise. If it turns out that promise isn't correct, you may be on the hook for that. That can obviously be an issue because of how complex video games are. By the time you're talking about 80-person teams, there's literally thousands of different assets that could each be individually copyrighted. All it takes is a couple of mistakes with some of the people who worked on the game, and the chain of title is now uncertain. Even if you own 95% of the game, the people who own that 5%, if you've been distributing it hundreds of thousands of copies without their permission, they could theoretically sue you for a substantial amount of money. So the other solution that's sometimes used, especially by American publishers, especially by more aggressive American publishers, is they're going to have an extra assignment that they're going to ask everyone who worked on the game to sign. It's going to be a one-pager, and they're going to say, developer, give us a list of all the people who work on this game, and then prove to us that each of them have signed this. And here's a one-page assignment, and we want all of them to sign it. Certainly doable. It's usually a little disruptive. I'd say most employees don't like signing new paper halfway through their jobs, especially because when you look at what those things say, they're usually extremely harsh and very broad. But it's one way to make sure that you can guarantee IP ownership because you're reaching through the developer and basically ensuring that even if they don't have the right contracts in place, you've given them a contract that's going to work for what you need it to do. And so the other issue I would say in terms of setting up your IP correctly, ownership of improvements and derivative works. Because even if you've got foreground and background correctly, that's in any case existing IP or IP that you intend to create. What if, to take the example of say the publisher giving the developer IP, what if the publisher has a lip syncing engine that works really well for English, but you're doing the localization into Japanese or French or whatever? And in the process of using the engine, you come up with a better way to make it work for foreign languages. You yourself have improved on the IP the publisher gave you. Who owns that? Default rules say whoever comes up with the improvement owns the improvement. And so obviously you end up, again, with sort of two people with veto rights. You can't use the improvement without the original, so the publisher has a veto right, but then the improvement was created by the developer, so the developer has a veto right. Again, not an ideal situation where two people can say no to whether something gets commercialized. So specifically addressing questions of improvements for sort of patented inventions, that's the domain where you really need to think about that and not overlook it. And on the copyright side, you have this notion of derivative works. That's another US notion. They tend to think of anything generated from an existing copyright as a derivative work, and there's a very complicated body of law about what is or isn't derivative and who owns what and what parts are protected and what parts are new or old. Canadian law is a little bit simpler, but what you need to know is that if you're dealing with Americans or if you have a contract that could be applied in the US, it's helpful to clarify ownership of derivative works. Because in Canada, you have one set of rules, in the US you have another, and again, US lawyers will just expect to see something about that. So quite apart from the practicalities, if you ever have to enforce it in court, if you're ever dealing with due diligence in a transaction, American lawyers will have their checklist, and ideally you want them to just check all the boxes off and not have to slow down and ask additional questions. Final point is co-ownership of IP, and Jeanette, what do you think about co-owning IP?
Well, in an ideal world, you avoid it for a lot of different reasons. If you don't deal with it contractually, who knows what rules apply to co-ownership? If you're in Quebec, is it the civil law around co-ownership? If someone is in other provinces, is it common law? And what about U.S. law for U.S. IP and then the rest of the world? So you never want just to let the law settle the issue. So in an ideal world, you'll figure out who should own the IP, and you'll have a single owner, and then if you need licenses back and forth, you create that scheme. If you really, for whatever reason, need to deal with co-ownership, good co-ownership language in a contract is never under 3 pages. It's 3 to 7 pages, actually, language around co-ownership. Why? Because you need language around ownership. What's the trigger to create joint ownership? If you're dealing with inventions, is the trigger US law pertaining to inventorship or Canadian law pertaining to inventorship? If it's copyright, is the trigger who is an author under Canadian law or other laws? So you need to deal with these. Triggers that are going to decide who owns, and then you need to deal with who's going to file if it's inventions, who files for patent protection, in which jurisdictions, etc. Who defends? So who prosecutes the applications for registrations? Who defends in court? Who commercializes? Who has the right to grant licenses, and so on and so forth. So we tend to try and stay away from that.
And yeah, I knew he would, Jean-Nic would have some strong opinions and good advice on this, and I just back that 100%. The rules of co-ownership under Canadian law are extremely unclear. All of our main intellectual property statutes say nothing about that. And if you try to say, okay, well, if federal law is silent, let's take a look at the provincial law. Applying 10 different sets of provincial law to a right that's theoretically national in scope is just a nightmare. We were involved in a dispute about co-ownership of a track on a musical track, and the other co-owner sold the track, and we said, okay, Quebec law applies. We get a right of first refusal because that's how co-ownership works in Quebec law. And if the other side bought that, and we negotiated something that worked for everybody, but if they thought a little harder, they could have said, wait a minute, why would Quebec law apply to a federal copyright? And that would have been a really difficult legal debate. And that's a debate that hasn't taken place in Canada yet, but that once it does, who knows where the courts will come down. So co-ownership is extremely fuzzy under Canadian law and not something that you want to have right now. Far better to put all the rights into one entity and then sort out through the contract itself who has the right to do what between the two of you. And so I understand that we're coming close to the question period, so we're going to move a little bit faster through the final 2 slides. But essentially, when it comes, these are some sort of more technical points to keep in mind. So one thing is that when you assign IP, there's some accessory rights that go along with it that often you need to spell out for the purposes of different national laws. So for example, when you're assigning the IP, it makes sense to say, I'm also assigning any damages claims that may exist so that the new owner can sue not just for future infringement or enforce their rights against sort of future third parties, but also against any past third-party infringements that might exist. There may or may not be any, depending on when you're signing this contract, but it's the kind of language you might as well include. It doesn't hurt, and it clarifies the scope of what people are getting. Similarly, for things like European Union patents, there's what's known as priority rights. Very technical point, I won't go into it, but it's a kind of right that you need to separately assign, you need to spell out and make sure that it's in the contract. Otherwise, you may not be acquiring what you thought you're acquiring. Same as rights of opposition and trademarks, again, very technical, but when there's certain kinds of rights, assigning the core IP right itself, the trademark, the copyright, the patent, may or may not bring with it all the accessory rights that you'd like to have. And so in that case, you need to make it clear that those accessory rights, by spelling them out, will transfer alongside.
And that is why laws are drafted by lawyers for lawyers.
Yeah, it's one of those areas where it can be a bit of a trap for the unwary. So consult with IP counsel. It's often more of a problem with foreign law than Canadian law, but even in Canadian law, there's some things you'll want to spell out, like the damages claim. Second bullet on the slide, ownership and access to source code. This is something that's not really IP related, but that's worth thinking through. Just because you own the copyright, you probably have an implied right to access the source code, but under what conditions, what kinds of delays? If the developer-publisher relationship ever breaks down, the publisher usually has leverage because they're the ones with the money. And if there's unpaid bills, they can use that as leverage. The developer usually has leverage because they have access to the latest version of the source code. And at that point, it becomes really interesting to know, okay, what does the contract say about source code? Do I have a right to access it if I'm the publisher? If I do, are they allowed to withhold access if I haven't paid a bill? If there's some sort of dispute, does that suspend my right of access? And so that'll be a really important practical consideration to try and hammer out. either in the contract itself by specifying that there is a clear right of access, and then depending on bargaining power, whether that right of access can be suspended if there's disputes. And then the other alternative is, as a publisher, you could simply have the developer do all of their coding on a platform you control. That then puts all of the leverage on the publisher side. And that's something as a developer you want to be a little wary about, because if a developer not only holds the cache, but also holds the code, if something does go wrong, you have absolutely no leverage whatsoever. Because all the code is on the or the publisher's platform. They could just lock you out of it. That happened to a client of ours. They were developing for a very aggressive American publisher. They got into a very tight deal, and when things broke down, they were just shut out of the publisher's system, and the publisher was able to essentially walk away because there was nothing that the developer had that the publisher cared about anymore. You don't want to find yourself in that situation. Finally, quick note on indemnification, reps, and warranties. We talked about using this to ensure that people own what they say they own. It can also be a question of guaranteeing that products don't infringe existing IP rights. And that's something that is, again, very heavily negotiated. With the number of US patent trolls in the software sector, the situation's getting better, but they're still there. Are one or both parties ready to guarantee that there's no infringement of a patent? Usually people are willing to guarantee I didn't infringe anybody's copyright. I know that my employees haven't copied anything, but when it comes to patents, I'm liable even if I had no idea that I was trespassing on someone's patent rights. So do I really want to put in the expense to try and figure out, is everything I do okay? Or am I willing to just launch blindly and again accept the risk that if a patent troll shows up, the costs are on me? So something to think about, heavily negotiated. Typically the publisher gets what they want in this respect, and the developer normally has to accept fairly broad indemnification obligations. But something that if you can push back and try to narrow the scope at least, that's something you should try to do. And I think we're just very quickly going to touch on the role of licensors, which Jean-Nic is going to speak about briefly, and especially the flow-through part.
Yeah, very, very briefly, just to go, because I know we're going to a question period, but just in the situation where the third-party licensor actually licenses the IP to the game studio, and then the game studio does an agreement with the publisher. What I've seen in the past when conducting due diligence in this space, and I'm going to use as an example, for sure, the best movie of the past 5 years, which obviously is John Wick. So let's use John Wick, and you can decide which one is better, 1, 2, and soon 3. So let's use John Wick as an example. You might have with the IP owner restrictions around what kind of game you can build for mobile or whatever. You might have restrictions on the type of violence you can have in the game. And I know Michael is a very good example, which is not John Wick related on violence. And what I found fascinating was that, and again, sorry, you might have language around indemnification. Even the publisher will need to indemnify us for this. And what I found fascinating was these obligations that were on the game studio and that clearly needed to be flown down to the publisher. I mean, there were no question about it on reporting, indemnification, on scope of game, on a lot of different issues. It was obvious that these obligations needed to be flown down to the publisher, and they just weren't. So, and on different games involving different IP owners. So just be very careful when you're in that situation to make sure that whatever obligations need to be flown down, that they are flown down. Because, I mean, I was looking at these contracts and I was, okay, they're in default under contract A. Oh, they're in default under contract B. Oh, they're in default under contract C. Not an ideal situation.
Yeah, and so just we're coming up to time, so just to sort of close the loop on licensors, we've put the diagram here where the licensor could be dealing directly with the developer, who then shops the game around to a publisher, in which case the developer needs to make sure the publisher agrees to everything that the licensor has required, like if there's restrictions on how the game can be advertised, what's considered in good taste, what the ESRB rating should be, that all needs to be put in the contract with the publisher. Otherwise, the publisher will put the developer offside basically accidentally. And vice versa if the publisher is the one who has the license. The publisher needs to make sure the developer creates a game that respects all of those conditions about violence, about content, about presenting things in the right light. And so I believe we've basically exhausted our time. So we're going to take the questions, I think, by email, and we'll be able to respond to everybody on an individualized basis. So I'd like to say thank you very much for coming out, both those who are in the room and those who are attending by web. And we'll hope to see you next time. Thank you
Thank
so
you.
much.